Industrial relations in Ireland are strong and positive. Relations between employers and workers are generally founded on trust and mutual respect. The basis of industrial relations is a process of collective bargaining between employers and trade unions. In this bargaining process, many areas are covered, such as rates of pay, hours of work, or holiday entitlements. Through collective agreements, procedural rules and practices have been established which govern the conduct of industrial relations. It is voluntary collective bargaining and not the law which is the mainstay of Ireland's positive industrial relations climate. But no matter how positive this climate might be, sometimes issues become divisive and threaten previously harmonious relationships. In the event of an industrial dispute, the state's role is largely that of facilitator, not enforcer. Through legislation, the state has established institutions to encourage dialogue and assist in resolving disputes. These institutions are the Labour Relations Commission and the Labour Court.
The Commission was established in 1991, arising from the implementation of the 1990 Industrial Relations Act.
The intention was that it would take away, if you like, from the Labour Court the routine sorts of disputes and make the Labour Court a court of last resort.
The mission statement of the Labour Relations Commission is to promote the development and improvement of Irish industrial relations policies, procedures and practices through the provision of a range of services to employers, trade unions and employees.
Well, the fundamental role of the Commission is to promote good industrial relations within the Irish economy. And in interpreting that policy function, the Commission itself provides a number of important services.
Principal among these free services are a conciliation service, an advisory service, a rights commissioner service, assistance and advice to joint labour committees and joint industrial councils.
Well, the Commission provides these services to the users, which in this case is the trade unions and the employers, in order to ensure that there is the stability in our industrial relations which is so necessary in a modern day economy.
The Commission also advises companies and trade unions on industrial relations best practice, prepares codes of practice for the social partners, carries out research in industrial relations and advises the government on forming policy in this area.
In effect, we interpret our role in a number of diverse ways, but all of them come back to the fundamental role of ensuring the minimisation of disputes within the Irish economy. We've also introduced new services in the sense that we have a new advisory service that assists companies and unions in change processes and in the management of change and in resolving local difficulties without having to resort to the conciliation service.
The advisory service's primary objective is to promote best practice in workplace relations and to put in place the structures and procedures necessary to achieve that goal. The service works directly with companies and their employees to resolve existing industrial relations problems or to establish new, more responsive structures appropriate to an increasingly competitive environment. The service also plays a central role at national level in promoting good industrial relations practices and procedures.
We've introduced 4 codes of practice, and over the last number of years we've had a number of seminars and workshops on major issues affecting company change and company restructuring.
Another core function of the advisory service is preventive mediation. Typically, this is carried out by joint working parties to resolve issues which, while not at dispute level, are of concern to both parties.
Welcome everybody, we're here today.
The Rights Commissioner Service is another important arm of the Labour Relations Commission.
This is a unique service to Ireland. I haven't come across it anywhere else in the world. And it's a quick response unit where at very short notice a Rights Commissioner can move in and look into a dispute. Generally these are disputes about individual problems, whereas the Commission itself in the conciliation service would be more concerned about collective problems.
Hearings typically cover areas of unfair dismissal, payment of wages, maternity rights, hours of work and holiday entitlements. Their hearings are conducted in private, except for those under the Payment of Wages Act 1991, which are generally held in public. In the event that either party disagrees with the recommendation of the Rights Commissioner, they can appeal it to the Labour Court.
I'm an industrial relations officer with
The Commission's main body of work is under the aegis of the Conciliation Service. The service provides an industrial relations officer to the employer and trade union in a collective dispute situation. However, if they wish, the parties may represent themselves.
The officer will bring the parties in, sit them down, listen to them both together, get some clarification as to what the issues are, and then work with each party individually, bringing about, over time, an agreement.
I understand from your correspondence that the dispute centres on redundancy proposals. Maybe you could tell us what your view on the situation is.
Sheila.
I represent the union members in the Mullingar plant of the company.
Discussions can be complex and intricate, often dealing with details of redundancy packages, pay bargaining, or with issues around work practices, such as changes in hours of work and conditions of employment. The Industrial Relations Officer advises each party on how its position fits in with general industrial relations practice and encourages dialogue, looking for common ground and room to compromise.
Damien, can we look at your need for involuntary redundancies, because this seems to be the biggest stumbling block at the moment?
The situation we find ourselves in is this.
I think one of the advantages of the service, of course, is the informality. People do feel relaxed. They feel that they can go and make their case. They're given every opportunity. And very often the Industrial Relations Officer meets each side separately so that they may want to make some points that they don't feel should be made in joint session.
Sheila, maybe if you could take your delegation down to room 102, which is just down.
That helps the Industrial Relations Officer to have a full understanding of all of the issues involved and helps them to facilitate some kind of a settlement. At that level, of course, of conciliation, it's really up to the parties to try and resolve the dispute. He acts as a facilitator to try and ensure that's done.
OK, well, management have indicated that they are willing to accept the 24 redundancies. They feel that they have gone the extra mile to get down to your figure of 24, and that the 24 redundancies would have to be immediate, be it voluntary or involuntary. So that's where they are at the moment, if you like.
We feel the company should be asked to wait to achieve their numbers.
In the overwhelming majority of cases, disputes are settled here at conciliation. But if no settlement emerges and both parties are agreeable, the Commission can refer the dispute to the Labour Court for deliberation. The mission statement of the Labour Court is to find a basis for real and substantial agreement through the provision of fast, fair, informal and inexpensive arrangements for the adjudication and resolution of trade disputes.
I think it is important for people to understand that the Labour Court is there to help in dispute situations, either in cases of individuals or groups. It's inexpensive, it's speedy, it's informal, and it's there to help.
The Labour Court was set up in 1946 under the Industrial Relations Act of that year. It has a wide range of functions which include investigating disputes under the Industrial Relations Acts, hearing appeals of Rights Commissioner and Employment Equality recommendations and decisions, investigating complaints of dismissal under the Employment Equality Act, establishing joint labour committees and investigating complaints of breaches of registered employment agreements.
The Labour Court.
The proceedings of the Labour Court are less formal than a court of law and are presided over by a chairman, not a judge. As at conciliation, the disputing parties may represent themselves if they wish.
Good morning.
But in most cases, they're represented by trade unions and employer organisations.
Mr. Chairman, I represent the union members in the Mullingar plant of the company.
The court division is made up of 3 members, with 1 person representing the employers, 1 person representing the trade unions and an independent chairman.
Mr. Hamill?
As you know, I represent the company management.
A written submission is presented to the court in advance by each side and read at the hearing. This allows the court to examine each submission in detail, getting clarification where required.
Thank you for your submissions. However, there are several points that the court would like to clarify.
Have the same length of service as their full-time colleagues.
But surely, Mr. Hamill, any payment due to such workers will be based.
I see you've outlined an alternative which you feel would result in 3 fewer redundancies.
That's correct, Chairman. At the moment,
When the court is satisfied it has heard all the issues, it closes the hearing. Later, it issues a recommendation on how the dispute might be settled. Although the court's recommendations on industrial disputes aren't binding in law, they're accepted in the vast majority of cases.
People have every opportunity to make their presentation, to ask questions through the chair. It is not a court of law. It's an industrial relations court, and therefore it is up to the chair of the court to ensure that everybody gets a fair opportunity to present their case.
At Tom Johnson House, the headquarters of both the Labour Relations Commission and the Labour Court, and across the country, many discussions, conciliation conferences, advisory sessions and court hearings are underway at any given time. Challenging and important work, usually behind the scenes, unseen but not unnoticed. The role of the Commission and the Court has been crucial from the point of view of improving industrial relations.
The existence of the Labour Relations Commission and indeed the Labour Court has been very important in our efforts to entice foreign investment to Ireland, because one of the things they require is stability. And we've had a very stable situation here over the last 7 or 8 years. And the Labour Relations Commission has contributed to that very significantly.
They do provide an invaluable service both to trade unions and employers, and the contribution I believe they make to our economic well-being will never really be quantified.
We're here to assist the parties to resolve their dispute. We don't have any decided view as to how a particular dispute would be settled. But what we are trying to ensure that the parties abide by procedures, that they use the institutions of the state, ourselves and the Labour Court, for dispute resolution. And by coming in here, they can effect a settlement that they themselves have contributed enormously to achieving.
There is a very close relationship between the Labour Relations Commission and the court, and it would be known to the regular users of the court or the LRC what the attitude of the court would be on various issues.
It's been very good from the employer's point of view to know that there is a professional agency available to resolve problems quickly at times of difficulty.
It is the availability of our service, and I think also the effectiveness, efficiency and professionalism of our officers that have led to the degree of success which we believe we enjoy, and which on recent surveys among our users they have indicated they enjoy as well.
The Labour Relations Commission and the Labour Court, vital intermediaries between two crucial economic factors of production, labour and capital. Key contributors to the success of the Irish economy.